I'm Eric Matisik, President and CEO of Highwing and co-founder of Denver Startup Week. This year's Denver Startup Week has never been more important. It takes a community to rebuild a community, and this week is about showcasing and highlighting the entrepreneurs and small business leaders leading through resilience and showing us a path forward. The best of Denver is in front of us, and may this week inspire you to be part of its story. Before we dive in, we want to say a special thank you to our title sponsors: Downtown Denver Partnership, JP Morgan Chase, Prologis, and Zero. And our track sponsors who've made all the great content you're hearing today possible: Battery 621 and Public Works, Capital One Cafe, Caudill Lending Source, Friday Health, Quizlet, Exactly, Zayo, and Zestful. Our headline and event sponsors are bringing the excitement this week. Thank you to Wix, Kinzon, MAPR Agency, Obsidian HR, Kickstart Fund, Promontory Mortgage, Molson Coors, and Comcast. Finally, thank you to our partner and member sponsors listed on the screen. Thank you for your support of Denver Startup Week. Without you, it's not possible. Finally, thank you to our partner and member sponsors listed on the screen.
Welcome everyone to Denver Startup Week. You are attending an event in the Maker Track, which focuses on all things physical products. My name is Lauren Kluk. I run marketing and communications at Colorado Lending Source. I'm also a former Maker Track chair, and I'm incredibly passionate about helping small business owners and entrepreneurs. Over the last 5 years, Colorado Lending Source has been a sponsor for the Maker Track, and we just love this organization because it really aligns with our mission, which is to foster the economic growth of diverse small businesses within our communities. Celebrating our 30 years of lending, we've helped over 4,000 businesses, creating over 30,000 jobs, injecting nearly $4.9 billion into the economy. Our loans range from $5,000 up to $5.5 million for a variety of business purposes. We're also a Kiva lender, which are crowd-funded loans up to $15,000 with 0% interest rates. When the pandemic hit, our team immediately shifted focus and created emergency loan funds for underserved businesses. We also facilitated over 700 Paycheck Protection Program loans and fielded thousands of requests regarding emergency funding for small businesses. All this said, we are an organization that truly cares about our borrowers and our small business community. If you'd like to learn more about our programs or what we do, please visit us on our website or feel free to shoot me an email. Thanks so much for having me. Hopefully we can meet in person one day and enjoy your session. And our small business community. If you'd like to learn more about our programs or what we do.
Hey everyone, and happy Denver Startup Week. This is the first ever completely Denver Startup Week, completely virtual Denver Startup Week. Obviously, there are random things that have happened during this week, and some things are absolutely incredible. Even if you notice, the Denver Startup Week logo is a little bit glitched out. I'm wearing one of the Denver Startup Week shirts. Just like the sponsor video, we just got to hear. I mean, double the sponsorship, right? It played twice. I'm pretty sure I could hear it twice. So double the amount. That was double as good. So I'm the Maker Track chair. I'm Michael Ostro. I'm also an organizing member for the Denver Startup Week committee. So if this is your first session that you're joining in on, welcome. It's probably not. You've probably been going to a ton of other sessions, so welcome back. I hope you've been enjoying Denver Startup Week. This is actually the last Maker Track session of 2020. So this is going to be an amazing session. All my friends are in this session as well. It's going to be amazing. So there's one thing that 2020 has taught us as Denver Startup Week. It's coming together as a community. I'm sure you at home have learned a lot of different stuff over 2020. I know I have learned a lot of stuff. Maybe, it's from isolation, but just in general, coming together as a community is of utmost importance. And then for Denver Startup Week, we make sure that at the top of that is creating a safe space to learn, grow, and connect. And that's regardless of gender identity, gender expression, race, ability, sexual orientation, or any combination of those identities. So thanks again for tuning in to the last Maker Track session. Enjoy it. I'm glad you've enjoyed Denver Startup Week. There's one more day tomorrow of other incredible sessions too. During this session, use the chat function. There's a Q&A function, and there's also a chat function. Make sure to use those to be more of an interactive session, as the session organizer just mentioned to me. But again, thanks for tuning in, and I'm going to hand it over to our session organizer now.
Hey everyone, thanks for joining us. As you probably already saw, and just make sure that you're in the right presentation here, we're here to talk about chicken versus the egg. Today, joining me are Schuyler Livingston, product developer and designer from Link Product Development, Dave Ratner, attorney, trademark and copyright attorney with Creative Law Network, and myself, I'm a patent agent at Voz Patents. And we know that there's a lot of confusion, there's a lot of mixed messages that you might be hearing when it comes to product development or intellectual property protection. And that's for good reason, because a lot of the time you'll see and hear some conflicting information based on where you are in the project and based on who you're talking to. And so what we wanted to do with this panel is help shed some light on that. And the goal of this is to give you some information that when you leave, that you feel a little more empowered, a little more educated as to when to ask the questions and when to understand when you've got these decision points as to when to go for product development or a patent or trademark and copyright kind of thing. So with that, I wanted to let each of us are going to sort of speak to our own specialty and sort of present what we think the chicken versus egg is. And then we're going to go into a discussion as to sort of a discussion between each other as professionals, trying to figure out how that interplays with each other's realm. So with that, I'm going to hand it over to Schuyler Livingston. I'll let him introduce himself and have at it, Schuyler.
All right. Yep. So yeah, as Michael said, as Dave said, I'm an industrial designer. I work over at Link Product Development. We work on pretty much everything in different industries, from medical to toys, some automotive, outdoor goods, mountain bikes, things like that. We have a pretty wide range of clients that come in, everything from established companies to individuals looking to form a startup. And so a lot of what we do is we look at those ideas and that they're coming in with, kind of evaluate and research their concept and where they want to go with the idea. And then, we go into kind of an ideation phase, a lot of sketching, kind of prototyping, quick mock-ups and things like that, some CAD development. And then we'll take them into the prototyping phase to build out models and verify ideas, pretty much all physical products that we'll work on. So everything from plastics, metals, carbon fiber, things along those lines. And then we'll do some market testing and then be a liaison into manufacturing. So hopefully that gives a little context. Again, the company is Link Product Development, so hopefully that gives a little context into what we do over here. So, and then Dave, I didn't know if you wanted to do a quick introduction before I jump into the chicken and egg.
Yeah, I'd be happy to. That's great. Thanks, Schuyler. My name's Dave Ratner. I am an attorney and I run a law firm called Creative Law Network. So what we do is we provide legal services to all sorts of creative people and businesses. And that includes a lot of intellectual property work, which is what we're here to talk about today, as well as kind of what Schuyler was talking about, the business formation, the contracts, the relationships. But a lot of it is, especially at those nascent stages, is a lot about the intellectual property protection. Certainly for the Maker Track, this is really relevant because we're putting stuff on there. Putting stuff out there, that is going to be, that we're going to want to protect. And this actually relates to a lot of other businesses as well. So today I'll be talking about trademarks specifically, but work on copyrights and also trade secrets, all sorts of other things. I'm also here representing Colorado Attorneys for the Arts. We call this CAFTA by the acronym, CAFTA for Colorado Attorneys for the Arts. It's a volunteer lawyers for the arts organization. I'm the chair of the advisory board for this organization. And basically what we do is we provide pro bono legal services to in-need creatives. Pro bono means free. We all know legal services can be a little expensive, and definitely when we're first getting off the ground, money isn't always plentiful. So for folks who need an attorney but can't afford one, if you have a legal issue that is related to your creative business, you basically contact Colorado Attorneys for the Arts. It's coloradoattorneysforthearts.org, and you submit an application, explain what your situation is, and then we at CAFTA can try and connect you with a volunteer attorney who will help you out for no fee. So I definitely want to make sure to spread that word as well as what we're spending on here today. And I'll let Eyvazzadeh take it over if you want to do your own intro, bud.
Thanks, Dave. Yeah, and so once again, my name is Eyvazzadeh. I'm with Voz Patents. Voz Patents is a patent agency that specializes in essentially getting patents. That's what I do as a patent agent. I help people, whether they be solo inventors or established businesses, obtain patents on their inventions. That could be anything from a made product, which we focus on here in the Maker track, to a method. And there's a couple different types of patents that I'll get into. But essentially, when folks come into me, a lot of times it's before or right after having spoken with someone like Schuyler or Dave. And so once again, and to reiterate what Dave commented on, help with intellectual property isn't always the cheapest, but at the same time, there's the entire aspect of bootstrapping and entrepreneurship that comes with Startup Week, and we understand that that can be a hurdle. And just as Dave was saying with the association he's with, there's also other options for directed specifically toward patents that the United States Patent and Trademark Office also provides some pro bono services if you qualify for it. So just know that that service, that resource is out there. And what we'll do now is sort of dive into our a little in-depth understanding of what we do and how that plays into the chicken and egg. And I believe we're going to have Schuyler start with that and go back through the rotation here and have at it.
Yeah, we'll get it going. So yeah, from a product design standpoint, you know, as I mentioned, we have a pretty wide variety of clients that walk in the door. Sometimes they have a prototype already and they're just looking to figure out how to execute it and get it in people's hands. Sometimes they have a general idea or a target market and no idea and no physical product idea at all. They just see an opportunity and they recognize that, you know, a product could definitely fit and solve a need, but they don't quite know what it is yet. And so when I was trying to think about, you know, this panel specifically and thinking about, you know, a lot of the questions we get, and a lot of the times we'll get people that walk in the door with a new product and they'll say, well, you know, I have this patent already. You know, I don't know if I'm tied to it, but I sketched something up and I got it patented. You know, where do we go from here? And then we also get people that come in with an idea and they're like, I want to get this in front of people, but I don't have any IPs figured out yet. I don't know if I should get it protected. I'm worried somebody's going to knock me off. And of course, as product designers, you know, we design products to solve a need. Usually it is a human need. It's a product for humans. So, you know, human factors and human-centered design all play into that. But we want to get it in front of people as soon as we can, to start to verify concepts and see if it actually works and get some feedback from people to really ensure that it is meeting that need. And so some certain things need to be in place, but really what it comes down to is that for us, it's industry specific. So as I mentioned, you know, linked product development, we do a lot of stuff in different industries. You know, something that's in the toy industry, for example, might not need the same kind of intellectual property protection or, you know, documentation and all that that a medical device would, or a firearms project, or something along those lines. So a lot of the times it really does come down to what industry you're in, and what is adding value to your product. So, if you have a new idea for a product that's in the firearms industry, and it has a very specific mechanical, novel idea that is really going to stand out amongst others because of that mechanical function, that's when we would almost immediately engage, Dave or somebody on the patent side to say, let's verify that it is unique in itself, and then we will continue down that path. But as product designers, we also like to know what else is out there in terms of legal protection for those ideas, because we have to work around that as designers. And then sometimes we'll get clients coming in and saying, hey, we really like this product that we saw. We're in that same market. Can you work around this patent? That one even gets trickier because, we're trying to evaluate all these different ideas. And so that gets really challenging. But that game really becomes, what do you pursue first? The product development or the patent? And honestly, in that situation, they do have to happen a little bit hand in hand, because we can't do our job without knowing what patents are out there and what is patentable about the idea. And then, of course, a patent attorney or agent can't necessarily do their job without knowing all the details and, mechanics or whatever it may be about how the idea works. Now, a lot of the times ideas will have, a little bit of value added because not necessarily of a patentable concept. It may be too close to something, not in the sense of infringing, but it's not necessarily a patentable idea. In that scenario, a lot of the time speed to market will be a huge factor. You can't necessarily wait for the patent process or other processes to protect your idea. Even going on Kickstarter is a risk, because I've actually seen people with ideas that launch on Kickstarter and then they get knocked off within that funding timeframe. So, your speed to market is also a huge variable in terms of figuring out which step to take first. No matter what, a big thing that we always encourage clients, and this is usually the first step for our projects, is to get a really solid NDA set up. And I'm sure these guys, can talk about that a little bit, but it also depends on what industry you're in. A lot of people are nervous sharing their ideas with anyone, really. And us as product designers, as I mentioned, really encourage you to get your idea out there, past your friends and family. We talked about this, I think, last year. We're not afraid the saying is, call your baby ugly. But, your friends and family might look at your idea and say, oh, this is amazing. This is so great. You should go get a patent. You should go, make 1 million of these, and I'm sure it'll work out great. But, as a product designer, we know that in order to have unbiased opinions, we need surveys, we need physical products to get in people's hands and say, how much would you pay for this? Would you be comfortable doing this? And so in order for that to happen, some element of protecting the idea has to be in place. And so that's where, the patent process, and Dave can speak to that, or the trademarking process and protecting your brand, your identity, your product. Some of that can be in place and in motion as us, as the designers and engineers are really trying to get this product into hands of people that, maybe they didn't start off by wanting to copy your idea, but, if they see that it has value, they'll either be interested in getting into it or trying to copy it themselves. And now, another thing, a lot of the times, or sometimes we'll have clients come in and they will say, I'm really just trying to get this idea to a point where I can go to a big brand and actually sell the idea. Now, that's a challenging position too, because we can make, if the product makes sense and we evaluate it and we do the research and the need is there and we can make a product to fit, we know, and we've seen bigger companies get interested in those ideas. And I'm sure if you've done enough research on this specific topic, you've probably heard of somebody going to a big company and saying, hey, look at this idea, I came up with it. Would you guys be interested in, partnering with me on it, or purchasing it for me and, getting royalties for the rest of my life and, passive income? That's the dream, right? And so I've also heard of a lot of stories of people getting ripped off from them. You know, big companies will say, "Oh no, we're okay. By the way, what kind of IP do you have?" No, we're all right. You know, what kind of legal protection do you have for your idea? And so in that scenario, we really want to make sure that all the steps are taken to protect the idea however they can, even though it's in the early stages, and really, you know, all the ideas around it. And, you know, I know Dave will talk about that more, but that's really, really critical if you are looking to go down that path. And so I think those are a couple of the scenarios where it does change up your strategy, how quickly you want to pursue protecting the idea, or if that's not even in the picture and you just want to beat everybody to market, and by the time it's out, you're on to the next thing. So as I said, for us, mostly we run into that when we want to do market testing surveys, get the idea in front of, you know, whether it's investors or, you know, larger populations, things like that, to really verify that the product has some value and is going to kind of meet that need that's out there. So, and I do see the question here in the chat. Right. So that one says that, you know, a lot of clients, the idea itself can't be protected. And we do run into that sometimes where it's too similar to previous ideas and things like that. And that's definitely more in Dave's territory. For us, a lot of the times that means we have a little more free reign. And as designers, we can, you know, start to go blue sky on the idea. We don't have to worry about running into walls. So from a product design standpoint, you know, we're happy with that when there's prior art out there that makes it almost unpatentable, because, you know, yes, you'd like to protect the idea, but from a design standpoint, that means we have free reign. We don't have to worry about stepping on any other products. It allows us to take some creative decisions that may end up actually being patentable at the end of the day. A lot of the times, from a design standpoint, we actually come up with something during the process, and then we'll talk to, you know, they'll go through their patent process and they'll be like, actually, this is the patentable item. And, you know, from our perspective, we were like, oh, we just included that because we needed some adjustability there. And they're like, no, that's what makes it entirely different from all the other products on the market. So that's why I wouldn't, you know, necessarily in terms of talking about what steps to take first, I wouldn't go all the way through product development first before protecting your idea, if that industry makes sense. And then, you know, the same can be said for going all the way through the patent process just on, you know, a couple sketches and whatever you may create. I think that, you know, protecting that idea in you know, steps as well as developing the idea is definitely a safe way to go. And as I said, depends on what value your product is adding to the market, what differentiates it, and then also what industry you're in, because some are crazy about battling, you know, in regards to very specific mechanical function and IP, and then some are very much about the brand and the brand image and the you know, the experience you have when you interact with the product. And so it all kind of depends on where those products lie. So
awesome.
That's my summary, and yeah.
Thanks, Schuyler.
Yep.
Dave Ratner.
Yeah, well, I get a different angle on this, right? Because these guys, Dave and Schuyler, get to talk about the actual product or what you're making. The intellectual property that I get to talk about is you can't touch, you can't handle at all. The trademark is really more the brand or the product line, the word or symbol, the logo, something like that, that indicates, well, in legal terms, we say indicates the source of a product or service. What that means is the trademark indicates what you're buying, what you're selling. When we look at in the business world and as consumers, we interact with trademarks all the time. I mean, every time you walk into a store, you're inundated with trademarks from every product on the shelf. Every time you open your laptop or your phone, all the logos and insignias are all trademarks. And the reason these trademarks are valuable is because when you see a trademark, you know what you're getting. So an easy example is you walk into the store, you want a beverage, you go and you grab a red can with some white script on it, says Coca-Cola. You know what that's going to taste like. Or if you're selecting your laptop and you see the Apple logo, there's a certain reputation for an Apple product, not just laptops, any Apple product. So there's a lot of value here, and the connection that we'll talk about specifically to this chicken and egg thing is that sometimes maybe your design isn't protectable, but your trademark is. And the trademark has a lot of value in getting your product out there. Sometimes there's going to be a lot of competing products on the market. Sometimes you won't be able to protect either at all or quickly enough the design that you've created, but you can protect the trademark, and that'll provide you with something to go to market with that has some distinctiveness. And what trademark is all about is distinctiveness. Again, distinguishing between one product from another, one service from another. So again, there's trademarks everywhere, every product name, logos like the Nike swoosh or the Ralph Lauren polo or the Apple for the Mac. I mean, all these things are trademarks. So the trademark is something that has great value, and it's something that we invest in. It's something that when you are putting a brand to market, you're going to, whether it's putting it on your website, whether you're printing business cards. I mean, in the old days when we used to actually go out and exchange business cards, hopefully we'll do that again someday. But you're gonna stand up a website. So what's gonna be your brand? What's going to be your product line, the name of your product? And that's really what trademark is all about. And it really is one of the things that happens with that I see with product design is that when someone comes in with an idea that isn't protectable, we may say, well, you can still, for whatever reason, and Dave can talk about what's protectable and what's not from the design side. But when that design isn't protectable, but you still think it's a great product, you want to get it out there, then what we will often say is, well, let's attach a great trademark to it so that when it hits the market, either hopefully you're going to be first to market, and definitely we hope you're going to be the best in the market. What we want to do is have a trademark that is really distinctive, that is catchy, hopefully, is something that people will recognize, so that even when you have competitors, people will think of your trademark in relationship to your product. I mean, there's so many examples out there that we've adopted, especially in the digital age. Think of something like Uber, right? There's nothing protectable in a ride-sharing app. But because Uber was, first of all, I mean, was pretty dominant other than Lyft, but also they've got a great trademark. It's a recognizable word, but it's kind of catchy. And they put great branding behind it. You don't say, I'm going to call a ride share. You say, I'm going to call an Uber, because they have a great trademark, they were quick to market, and they got some great market share. So talking about a little bit what makes a great trademark, because obviously I said, well, Uber is a good trademark. Why is it good? Well, one thing about a good trademark is it has to be distinct, different from other trademarks for similar products or services. What we want to do with trademark is we want to avoid any confusion in the marketplace. So if I wanted to start a ride sharing app and I called it Duber, that's not going to work. I'm not allowed to do that because I'm going to create confusion. It sounds too similar. And even if I started a ride sharing app that had a very similar looking logo that's black and gray, very simple like they do, that could be a cause for confusion. And again, the point of the trademark is so the average consumer can recognize the source of a product or service. So we can't have trademarks that are similar to each other, because that will cause confusion. They won't be able to distinguish the source of a product or service. So when we're coming up with trademarks, and this is something to the extent you are trying to bring a product to market, you need to come up with a name, a trademark for it, maybe a logo as well. Trademark also protects taglines. Just do it. The one. I mean, there's so many great taglines out there as well. So whenever you're coming up with your whole branding package, we want to make sure that all those aspects of your branding package are distinct from competing products or services. There are also a few other things we want to avoid in trademark. And the most common one is descriptive trademarks. So it's very easy and it's often very attractive to come up with a trademark that describes what you're selling, because you want the consumer to know what it is when they encounter it. And so, I'll use the ride sharing app as well. If we said best ride share was the name of our new ride sharing app, well, that's descriptive. But the problem with the descriptive trademark is that you can't get protection for it. And I'm going to talk about trademark registration and protection in just a minute. But the reason I mentioned this is because the reason we can't get protection for a descriptive trademark, and the reason the descriptive trademark is not a good one, is because we won't be able to get the protection, because if they gave us protection, if they said, okay, Dave's the only person allowed to use best ride sharing for his new app, well, then no one else could use the words ride sharing to describe their app, because I'd have those exclusive rights. That's what trademark rights do, is they give you the exclusive right to use your trademark. And that wouldn't work if I wanted to start Dave's Law Firm. That's not going to work either. They can't give me the trademark for law firm, then no one else can use the trademark law firm. So we want to avoid those descriptive terms. And also avoiding common words and phrases is a good idea, only because there are so many millions of trademarks out there. So many people have used these common terms that we often run into someone else already has that trademark, basically. And again, in the trademark production process, as we're coming up with a trademark invention process, you really want to avoid things that are going to be similar to someone else's trademark. However, one thing to remember about, or one thing to point out about that similarity issue, is that the similarities only matters if it's for a similar product or service. So you can have a similar trademark if it's not likely to cause confusion. And confusion, again, is what trademark is trying to avoid. So with an easy example of this is the trademark for Delta. Okay, we have Delta Airlines, we have Delta Faucets, we have Delta Dental Services. And all these trademarks can coexist because there's no likelihood of confusion. You're not going to buy a plane ticket and think you're getting a faucet. They're distinct products and services. They're in distinct industries. So if I want to do Uber for water bottles, I can have Uber water bottles, because people aren't going to think, oh, that water bottle must be related to the ride sharing app. Again, we want to avoid confusion. Really what it comes down to when selecting a trademark is that the best trademarks are what we call fanciful marks. A fanciful mark is a made up word. Because if you make up a word for your product, it's very unlikely someone else is going to have a similar trademark, right? You made it up all by yourself. And if you think about just in the consumer world, there's a lot of fanciful trademarks that are household names. Kleenex, Xerox, Kodak. These are all made up words, and that we call them fanciful marks, and that makes them really strong trademarks because they're not similar to any other word or any other trademark, and they're not similar for any trademark in that particular or in connection with that particular product or service. So one of the things about trademark is that we have a registration system, basically, and that is all through the U.S. Patent and Trademark Office. So Dave and I get to cross over here. Patents and trademarks are all in the same office, but they actually really don't talk to each other very much. So there is federal protection for trademarks, but what a lot of people don't understand is you establish trademark rights simply by using the mark. So if you want to put your product to market, irrespective of the patent issues that Dave's going to talk about, but taking a product and putting it to market, if you start offering your product under a trademark, you establish certain rights. They're called common law rights. And the thing about common law rights is they're limited. They're limited only to the geographic area where you use them and the specific product or service you use it with. The reason we have a federal trademark office, we have federal trademark registration, is because a federal trademark registration gives you nationwide rights, gives you far broader protection. So it gives you priority rights throughout the US, which is a really, really strong thing to have, because you may not have sold or even marketed your product in certain places, but if you have a federal registration, that means no one else anywhere in the country can use a similar trademark for a similar product or service. The way that we register trademarks are in classes. So there's 45 different classes, 1 through 45. And every product or service in the world fits in to one of those classes. So for example, you've got a new clothing line. Well, all sorts of apparel fit into class 25. So you would say, I'm registering this trademark for shirts, hats, and hoodies in class 25. Or you've got a new app. So it's a downloadable app. You're going to register your trademark in class 9 for a downloadable application, namely whatever it is we describe it as. And that classification system serves to, again, help us distinguish the trademark. So again, Delta, using that example, the Delta Airlines is in that services class, but Delta Faucets is in a products class that's completely separate. The trick to this, however, is that a lot of people think, well, I'm creating this particular product and it's nothing like this other one, even though they're in similar industries. The trademark office, they don't really do nuance. They don't really see the difference. If you say, well, I'm creating, I don't know, a new e-bike, okay? And the e-bike has nothing to do with those e-scooters, those electric scooters. It's completely different. They're not related. The trademark office sees these things as very related. They're both products that are electrically driven that you use to get down the street. And this goes far more granular than that example. But the point is that you may say, well, there's a similar trademark out there, but it's not really for a related product. The trademark office may see it differently. And I think that we'll always encourage people to do a trademark registration because it provides these broad rights. But the process for getting a trademark registration is very detailed. It's very difficult. The trademark office is very picky. So you'll actually, if you go to the trademark office website and you look at the FAQ, it'll say, should I hire a lawyer to do my trademark application? And it will say, you're not required, but we highly recommend you consult a lawyer. And that's partly the application process. But in fact, the first thing we do, and this is where we're going to get into some chicken and egg issues, is the first thing we do is usually conduct a search. So going back to what I was talking about earlier, about how we want to avoid confusion, we want to avoid there being two trademarks that are similar to each other. Well, the only way to figure that out is to look. And people will say to me, well, I Googled it, right? So my new app is Uber, I Googled it. Well, that is just scratching the surface, because the trademark office is going to do is they're going to do a very in-depth and comprehensive search. They're going to look for every trademark that looks like, sounds like, or could be confused with your trademark. So every spelling, every different way you could spell it. They'll look at other languages. If you're using a common word, if you're, if your word is going to be chair, right? They're going to look at chair in every language out there. Or if chair is in your trademark, chair would not be a good trademark. And so that search process, it's not as much of a Google search. It is more of it's a search of the trademark office database, which has its own search functions. And so what we'll do is we will do this whole comprehensive search before we submit a trademark application, because we want to get ahead of the game, right? We want to get ahead of the trademark office, especially because it takes many, many months for them to get through your application. So you don't want to submit the application, wait 3 or 4 minimum months, and then find out, oh, there's another one out there. So that search is really important. Of course, again, where we're getting into the chicken and egg thing that we regularly interact with clients about is, well, I've got this great idea for a trademark. Do I need to search it first, or can I just start using it? I've got 5 different ideas for the trademark. Do I have to search all of them before I can start using it? Because you don't necessarily, again, you don't need the registration in order to use the trademark, but we want to make sure, or we want to have the best chance possible of getting that trademark, so that you don't spend all this time, money, and energy on branding and then find out 6 or 8 months later, oh, I can't use that trademark. For the registration process, as I said, rights are based on use, but you can actually submit what's called an intent to use trademark application. So an intent to use application is basically saying to the trademark office, I'm not using this trademark yet, but I want to reserve it. And I want to make sure I can clear it. And then once I put it into use, I'll let you know, you can give me a registration. So you submit an intent to use application. It goes through the same examination process as an in-use application. But once it's approved, you basically have, well, you'll have 6 months to put into use, but then you can file a 6-month extension. You can file up to 5 6-month extensions. You can actually reserve 3 years ahead of time. So during this product design phase, during the product development phase, during the manufacturing phase, while you're waiting for it to come from the factory, beta, all of those things, you can still be getting your trademark reserved. And it's really, again, that's why we find it to be worthwhile as part of the development process, is to make sure we can reserve that mark ahead of time and know that once we hit market, we've got a protectable trademark. So really, I think that the search is one of the biggest, as far as at this stage that we're talking about today, the likelihood of confusion issue, the search and investigation process is a big part of it, but it really goes back further than that. It's about selecting a good trademark. It's about selecting a trademark that isn't going to run into problems, which is why I was talking about the fanciful marks, made up words, things that haven't been used commonly, things that don't describe your trademark, and selecting a good trademark ahead of time will help you down the road. So there's a quick overview. Lawyers really like to talk. I'm going to try and shut myself up and let the patent agent talk over here, and then we all get to banter and answer your questions.
Thanks, Dave. Actually, you made me remember I want to sort of market some phones of the name Pear and sell them out of my sandwich shop called Biznos. All right, guys. So I'm going to talk to you about patents. So in essence, at the root of it, what is a patent? A patent is sort of it's typically issued by a government authority or licensing system that gives you the right to exclude others from the practice of your invention. I like to put it in the sense of, I try to help you get a sandbox that you get to kick other people out of. The patent itself doesn't necessarily create that action of kicking other people out of, but it gives you the right to do so and to try to enforce that patent. Now, as far as what I do, typically people come into me, whether it be the solo inventor or the business, whether it be small business or well-established business, entrepreneurial, you name it. What ends up happening is people come to me with an idea. And like Dave, I do a search because I want to see what's out there. Now, the interesting thing is, and I'll be curious to hear your feedback on this, Dave. When a patent is actually submitted, there's actually an 18-month period for which that patent is not published. That application is not published. So there's a blind spot with applications, with doing a search. So if anyone wants to sell you a search at like $10,000, $15,000, buyer beware, right? Because you could throw millions of dollars at a search and you're not going to have the whole answer. And sometimes it's sort of that 80-20 solution that you're looking for. You want to get 80% confidence level with 20% effort so you can actually push the effort and your budget toward going after a patent. Because whether it be $10,000 for a search that won't get you a patent or $10,000 that might get you a patent, I'd prefer the latter. So one thing I will say, and I tell this to quite a few people before I get into a little more detail about patents, is that patents are yet another tool to increase the value of your invention, of your product. And I would argue that each one of us has one of these tools to increase the value and of the product, whether it be the actual product or the marketability or the ability to keep other people from coming into our sandbox, so to speak. So what I want to say is that patents are a business decision that you need to make. And it may be made based on what's your strategy, or did I find something in a search, or how much money did you put into product development to make sure that you were different from everyone else, right? Or am I going to be focusing on my trademark and the brand instead? Patents are just the same way. And the ultimate thing is when people come in, they want to know if something's patentable. What makes something patentable? What makes something patentable is A, is it novel? Is it new? Has it been done before, right? Now, you can say, oh, there's so many things out there, nothing's actually new. That may be the case, but it can be an improvement on something, right? Now, if you're improving something and it's slightly different than the predecessor or what's already out there, that could be patentable. The other criteria, other main criteria, I should say, is it obvious? Now, if I were to take a phone or forget that, how about a remote? Let's take a remote and I decide I'm going to add, I don't know, Bluetooth to it. I mean, most people would understand that an electronic device and you're adding Bluetooth to it is obvious. And it's in this way that the examiner also has to think about whether or not your application is obvious. And the way they do so is that similar to how Dave's talking about how the Patent and Trademark Office, when they're looking at trademarks, they look in things that are related. They'll do the same in patents. So if you're coming up with a new design for scissors, they're not going to go and bring in some sort of water bottle to sort of combine with a pair of scissors to get the plastic bit for your scissors. They're looking for things that are relevant, things that are related. And would it be obvious to combine this pair of scissors with this pair of scissors to result in your pair of scissors as invented? Now, I will always say that they are objective rules, but the people who apply them are subjective people. We're not robots. And there can and will be applications that one of them will get through and the other one won't. And that's sort of part of the reason that I really enjoy helping people with this, because it's something that it's a fun little puzzle, right? So we've talked about why something is patentable. So the question is, what can you patent? For the purpose of this conversation, we're going to talk about utility patents and design patents. Because Dave just talked about trademarks, I'll talk about design patents first, which I don't talk too much about. Design patents protect the ornamental features, how something looks. And it acts more like a trademark sometimes than it does in the realm of a utility patent. Because, for instance, there is a design patent on the shape of an iPhone, right? Now you see the logo back there, and that logo allows you to know, as Dave said, that you're buying an Apple. But at the same time, the shape, the look, the feel of the product can very much lend itself to that same effect of, am I buying an Apple product? In fact, one of the largest Supreme Court decisions based on patents was between Samsung and Apple, because Apple was found to be infringing on Samsung's design application, their design patent. So design patents are a narrower scope typically. They actually cost less to get through the process, but they're not to be discounted as being not valuable. They certainly have their time and their place. And sometimes you'll have a mechanism or invention that structurally and functionally it's brand new, it's never been done before, but you've also put in the time and the effort to design it that it looks different than everything else out there. And that might be a potential situation that you want the utility and the design application. Sometimes, as Schuyler was saying, you might have something that isn't patentable. And once again, we think about patents in the utility or functional sense. You could potentially design a phone that looks like, I don't know, a cat or a water bottle or something, right? That it looks like something completely different. You're not protecting the inner functionality or what it does. You're just protecting what it looks like. Okay. So now moving over to the utility applications, once again, you're protecting the functionality. You're protecting what it does or how it does it. And a lot of times it's based on the construction of it and how things and pieces and parts go together. So with the utility applications, you've got two options. So when you go with the design, sorry, let's take a step back. The design, you have one option. It's a design application. There's one form of design application. There isn't one that you file before the other. It's just the design application. While in the utility applications, you have the provisional and non-provisional. The provisional is a placeholder. It holds your place for 12 months. There's a number of reasons for this. It can hold your place so that you know that someone else isn't going to file before you. So you hold your place in line at the USPTO, the Patent and Trademark Office. And in doing so, you can confidently go and actually talk to people about your product. You can go and potentially go to these big corporations, knowing that if your product is patentable, that you have a leg to stand on, that you might make it through the process and have the ability to say, no, this is my sandbox, get out. So when you get to the provisional application, oftentimes you go the provisional first because you're bootstrapped, or you don't know if it's marketable yet. You don't know if it's saleable. You don't know if you've finished designing it. Right? You may have further iterations that you want to push through before you jump into the deeper end of a non-provisional. The non-provisional would be filed within 12 months of the provisional if you file the provisional. And that non-provisional is what can end up resulting in a protectable patent. So the benefit of the provisional to the non-provisional, on top of all those other things I spoke about, is that the provisional establishes that date, that stake in the sand. If the provisional has elements A, B, and C in it, and your non-provisional, let's say you didn't really necessarily add much to it, and so you have elements A, B, and C, it's as if you filed the non-provisional at the time of the provisional up to a year earlier. Anything that's new in the non-provisional is new and has the later filing date. So that sort of brings me to the chicken and egg. With patents, there are certain criteria or timelines that you have to follow. And one of the most important ones comes before you file your application, or I should say, ideally, it doesn't happen before you file your application, and that is public disclosure or offer for sale. In the US, if you have a public disclosure or an offer for sale, it starts a 12-month clock. If you go through that 12-month clock, after you spoke to someone, you offered it for sale, you listed it on YouTube, you have it up on your website, you post it on Instagram, you name it, after those 12 months, you have potentially forfeited your patentable rights. To make things a little more complicated, if you wanted to go after international protection, you don't have any grace period. You have 0 grace period. If I posted something on Instagram today and then filed an application for it tomorrow, that Instagram post could very well be used as prior art against me, even though I filed it. So the chicken and egg is a matter of public disclosure or offer for sale versus the filing date of your initial application. I like to try to encourage my clients to have something on file prior to that public disclosure or offer for sale. Granted, there's ways to make sure that conversations that you have are in confidence. You might have your business attorney create an NDA for you. But at the same time, although that may or may not be enforceable, it's not going to do much for you if someone files an application before you, or if they publicly disclose it, because you may have some recourse, but it's out in the wild now, and it may still end up being used as prior art against you. So that's where my chicken and egg lies. And I think that sort of brings us kind of full circle to where we're going to start mixing it up. We're going to start talking to each other. We very much want to see your questions. If you want to submit them into the question and answer portal, we'll do our best to answer them prior to the end of the presentation. We still have a good 35 minutes here. And yeah,
there's one in there, Dave, that I'm happy to take up. The Q&A or the chat function, either one works for us. And Kate did ask a question about, and I get this all the time, why should I hire a lawyer to do an internet search? And I think, Dave, you probably kind of have the same thing when patent searches. The thing about the search, at least I can speak from the trademark side, that the search will likely should reveal hundreds, if not thousands, of similar trademarks. If you didn't find any, you're not searching right. There's just literally millions of trademarks in that database. And it's not, so when we do a search, we will get those thousands and we will call out just the ones that actually matter. And then it's really about the evaluation. It's about looking at a similar trademark and saying, is this a problem? Is it in the same class? Is that class broad enough to fit both? Is it in a different class, but it's still in what's called the similar channels of trade? Channels of trade means something may be sold or offered in the same area. An example is I had a client who was doing kitchen interiors, and they found a likelihood of confusion with a home goods store. And we said, we're doing kitchen interiors, they're selling toilets. What difference does that make? And the examiner said, well, you can find all those things in a Home Depot. They're all in the same channels of trade. So you think there's no relationship here, but it's just the experience. It's not that we don't believe our clients are smart enough to do an internet search. It's just learning. It actually goes very much to what Dave was saying. The examiners at the Patent and Trademark Office are human beings. And they're following a rule book, but you were still guessing what they're going to do. We need to be able to predict.
That's really interesting about the Home Depot. I would have never thought that. And
I was not happy about
it. For the search is that I actually, and you may, I'm sure you do as well, I actually encourage people to do their search before coming to me. But at the same time, I'm going to use that to seed my search. So, because at least in my situation, nobody's going to know the invention better than the inventor. And I believe that them doing their search, using the free tools that are out there, like Google Patent Search is an amazing free tool. And I sort of pitch that to any client that wants to sort of save some money, like go try to find it. If you don't find it, come to me and I will try to find it. But because you did that search, at least in my scenario, it makes my job easier. And it allows me to go deeper rather than just sort of that 80-20 becomes 90-20.
Well, and it is the chicken and egg thing, right? It's like we want you don't, it's not that anyone has to come to one of us to come up with an idea, to come up with a trademark, to come up with a product. It's more about those next steps. Yes, of course, do your research. You don't need to pay us to do simple research,
right?
But it's that next level of making sure, yes, I'm going to invest in this. I'm going to dedicate to this. I'm putting all my chips on the table for this.
And we actually, we do something similar. It's not through, as structured of a portal, but essentially we'll encourage customers to really verify that, look at competing brands, look at competing products, what makes yours different, what makes it better, do all the online research that you can. And we'll encourage them to do that on their own. But the difference is, when we're doing that here, a lot of the times we'll buy, we'll go get every competing product and we'll start using it and we'll see what it's like and we'll get it in people's hands and be like, what do you think of this? Does this look right? Does this feel right? So for us, it's not necessarily, there isn't, a site you can go to and Google's a great start, but it's one of those things for us. It's a lot more subjective. There are objective ways of going about it, but there are some things you can do yourself. But a lot of the times for us, it's, building out a SWOT analysis, looking at competing products. If there's nothing else out there like it, what would knock it off first? That kind of thing. So yeah.
Yours sounds like more fun. You get to play with things. That sounds like more fun. To me.
Yeah, and break stuff and take it apart sometimes.
Yeah.
Yep.
Sounds like childhood. Although it's a little out of order, I'm going to answer Matthew Hartley's question. How much does a search cost on average? That varies. That varies from professional to professional. In my case, if I'm doing just the search, what I do is I cap it at $1,000. Because if I can't find something within that hour, that sort of span that so my typical billing is $250 an hour. But at the same time, I prefer doing flat fee because it allows me to spend more time on things. So it's based on 4 hours, but it might be 5 or 6 hours, just putting that out there. But I like trying to do the search within that $1,000 cap because I believe that if I can't find something within that time frame, at that point, it's kind of what's your return on your investment? I don't want to put so much money into your search that you don't have the money to go for a provisional application, right? I will say beware of places like InventHelp and things like that. They're very predatory. They've had a lot of lawsuits against them. I had a client, unfortunately, come to me after they had spent $12,000 on a search that resulted in just marketability assessment. And it was not even sort of an assessment of patentability. And in reality, that $12,000 is enough to get a lot of my clients through the process. So I'll let you guys sort of address your search.
Well, yeah, I mean, ours depends also, and it just really depends on how many classes we're pursuing, because each class that we add is going to take more time and therefore cost more money. We do it on a flat fee as well, and I also will discourage the easy, seemingly quick fixes like LegalZoom or things like that. I actually had a client come to me with a LegalZoom search, and he said, "Well, here's the search." Well, I can go buy that search too. You get thousands and thousands, literally a stack of paper. To the extent you print things out, you get thousands of results. And what we're doing, the kind of value add that we're providing is we go through all that and say, these are the ones that actually matter. And we can do an evaluation. So I guess it's not so much the search. Anyone can go and pay for a search online. We get all those results. It's going through those results and saying which of these matter. And we do a full analysis. We provide options and recommendations, all kind of written in a way that's easy to understand. I mean, even just deciphering the code that the trademark office uses can be confusing. Understanding the classification system can be confusing. Ours tend not to be more than $1,000 either, Dave, or similar to Dave's. It is something we do it on flat fee based on the number and complexity of the trademark, words, designs, logos, and also how many classes you're going to be pursuing.
Yeah, and from the product development standpoint, of course, as I mentioned, we work with such a variety of products in different industries. I mean, some things are a simple injection molded plastic part, and then other things are, motorcycles. And so, with upwards of thousands of parts. So it varies for us a lot. I know that just the way we engage projects and the way that we do things, a lot of the times we won't take on projects less than $10,000. And then, the medical products and some of the really big ones that have, a fair amount of, documentation and steps you have to go through and serious investment can be anywhere, on the higher end of hundreds of thousands. So I know the motorcycle project that we worked on a handful of years ago was definitely, much higher than that, but that one was unique in itself. So it really does vary depending on what steps you want to take, but a lot of the times we really want to make sure that we are making sure it's an idea that's going to solve a need that needs to be out there, that has some warrant to it. And to Dave's point, there are cheaper options out there, and InventHelp being one of them, and sometimes we get clients that come to us and say that they've spent 20 to 30 grand in that direction already. And we look at what they have and we basically have to start over. So that can be a really challenging position to be in. That's not to say that there aren't, some more cost-effective options out there, but, there are, differences in terms of how they'll go about it, the resources on hand, things like that. So definitely worth doing your research and having conversations about it with the right people. So.
Yeah, I kind of see it as insurance somewhat, because we also, and Dave, I imagine you run into this with all folks who have submitted their own application, but then it gets refused, and then they come and find us and say, well, help me fix this,
Right.
and not that, I'm not, you can take whatever path you want, but I think that the for what it's worth, just to clarify the trademark examination process is that if the examiner refuses the application, it's not dead in the water. You have an opportunity to respond and argue in favor of your trademark. And even if they refuse it again, you get another opportunity to respond. So there's a lot of back and forth that can happen. I know it's the same in the in the patent process.
Yeah, it really is. And I mean, I say, as I said, the chicken and egg, what really plays into it is the cost of preparing an application with a professional. I get it. It's, for instance, for me, my provisional applications are typically in the $3,000 to $4,500 range. Based on complexity, right? And then the non-provisionals are actually an increment further. I typically do 1,500. My model may be similar to other professionals' models. It may be a little more expensive, it may be a little cheaper. I'm in no way at the extremes of either end. But what I will say is that it's never going to be a cheap process. And I understand that when I say have a provisional application or some sort of application on file before public disclosure, sometimes that's impossible. I get that. Like if you want to put your eggs, so to speak, in the basket of product development and trademark before you go after patents, that's a business decision. Now, a lot of times when I see the self-drafted, the pro se applications, a lot of times they're missing quite a bit, and there's some nuance that's missed and whatnot. But what I will say is that if I had to choose between a self-drafted and filed application and no application whatsoever, I would go with the self-drafted. I would go with the self-drafted, have as much in there as you can. If you have a CAD model, put in as many screenshots of that CAD model as you want, right? Generate some PDFs, put that in there, describe it how you're using it, some scenarios of how it's used and how each piece and part is interconnected. And you're going to be in a much better position than not having an application. And I can work with that based on the date. Will I have to add a bunch to it, a lot of language and verbiage and work on the claims and format? Sure. But it doesn't leave you dead in the water if, let's say, you want to go for international application. I would say...
We should talk about international, by the way.
What's that?
We should talk about international because I think there's some chicken and egg there too, like, as your what those plans are.
Yeah. So the international application, the very interesting thing there is that, like I said, you don't have any grace period if you have public disclosure. Now, the nice thing, though, is you get to file that within 12 months of your first filed application. So whether it's a provisional or a non-provisional, you get 12 months before you even have to make that decision. From there, if you want to file international, it's based on the application size, it's between $2,500 and $3,500 typically. And what that is that amounts to, I like likening it to now when people apply to college and such, and it's been like this for the past 20 years or so, they use a common application. Similarly, with it's called the Patent Cooperation Treaty. It's the PCT. When you file the PCT, it gives you the ability to go after about 159 different countries. Now, each one of those countries will cost the same as another patent application likely. So understand that that becomes a multiplier on cost. But the cool thing is that with the PCT, you pay that $2,500 or $3,500 when you've decided that that's what you want to do within 12 months of the initial filing. And then from there, you have 18 months to actually enter what's called the national stage. And that's where those additional costs start building up. So that gives you a 30-month runway of knowing when that cost is coming. And sure, like it's about, let's say $3,000, 12 months in, but for a startup and someone that wants to protect their IP, if you've put a lot of money in product development and you're protecting your brand, that $3,000 actually, although it's a good chunk of money, it's not that massive when you take into consideration what it takes to launch a product internationally. That said, I'd say 10% of my clients go international. It's all a matter of your market. It's all a matter of what you want to protect. It's all a matter of your business.
Yeah.
And sorry, Dave, to answer the question about the pathway through Canada, if you're a Canadian citizen or you live in Canada, I believe that you can file a provisional there. But if you are based in the US and or a US citizen, filing the PCT is how you would file in Canada. Or if you wanted to simply file in US and Canada, you can file Canada as just another application within those 12 months instead of filing the PCT. PCT makes sense when you're 3 countries or more. Under that, it makes sense just go individually. You don't get that 30-month runway, but it's cheaper. And you would, for instance, if you came to me, I would have the domestic application, and then we would work with a Canadian foreign associate who is licensed to practice before the Canadian Patent and Trademark Office. And then that's how we'd go after Canada.
Well, on the trademark side, I mean, similar trademark is domestic. Each country has its own trademark office, its own trademark laws, its own trademark examination process. So we generally, you apply in each country. We can apply in multiple countries. There is there's a treaty and a World Intellectual Property Office, but each country has its own trademark. So sometimes, yeah, we'll file in the US and also file in Canada at the same time. The exception is there's a European community trademark that includes the EU. There is an African that includes a bunch of countries in Africa. So there are some exceptions where you can get a multi-country protection, but for the most part, you're applying in each country. So we're generally only adding additional countries as the client is planning on expanding to those countries. And if we think we're starting in multiple, it can be a big expense. So it's part of that same analysis we've been talking about this whole time.
Yeah. Schuyler, do you get into sort of international like designs? Do you have regulations that come against you?
A little bit. I mean, we have a few different considerations we go through, especially on the the research side of things. We really want to make sure that we're designing a product that will meet the needs of wherever we're designing the product to be used. Of course, in different cultures and things like that, you'll have different color associations. A lot of what we incorporate into products is the color and the look and the feel. And what may be comforting and approachable for a U.S. market is not necessarily the same for other markets. So around the world. And then of course, looking at incorporating the ability for, when we're talking about consumer electronics or medical devices, making sure that those can be used with different power sources around the world, and making sure that they fit with, UL and CE and all the different regulatory marks and agencies that need to go through that testing, then that's definitely important. That's not necessarily something that we, go through the testing with you, but we will, with our electrical engineering partners and all that kind of stuff, we will make sure we design the right, shielding, protection, all those kinds of things, openings, small parts, definitely come into the design. So it's a consideration, but yeah, there isn't necessarily any timeline, factors or different ways to strategize about it. So.
Awesome. Awesome. I think this next question, Dave, I think this is a perfect question for you.
Well, I think you mean Michael's question about the hammer and the art?
Yeah.
I think it's actually yours, as a matter of fact, because it's really about the invention on the hammer.
It's a nice blend, actually.
It is interesting. And but just a reminder, everyone who's with us here, please put questions in there. We're here for you. Right? We're here to answer your questions and make this interesting for you. Michael's is fun. I love this. I love this question. I mean, certainly, I think Dave's been mentioning this because I do work with a lot of artists and the protection of. Interestingly, we're talking about IP today, trademark and patent. The third most common type of IP is copyright. And copyright protects all sorts of creative work. So it protects pieces of art or works of art, whether that's visual art, video, music, text, choreography, architecture, all that's protected by copyright. So the issue of the hammer and the art, certainly when you create the artwork with that hammer, the artwork is protected by copyright, which is a little outside the scope of what we're talking about today. I actually think, I think actually it is a little relevant here because we're on the maker track here. And I think a lot of makers are artists of a sort, if not entirely consider themselves artists. And copyright does protect any original work. So any sort of sculpture, most likely artwork that you create with a hammer, probably it falls in that realm. And copyright does protect that. And copyright exists as soon as we create the work. It's just that the rights that are protected by copyright are different. It prevents copying, it prevents duplication, reproduction without permission. The owner of a copyright has the exclusive right to reproduce and also to display, perform, create derivatives, so create other versions of the copyright. So when you use that hammer to create that art, you're creating a copyright in the art. I don't think you're sacrificing any risks in the hammer. Because you haven't publicized the hammer, and Dave can speak to that. I think that feel like a good lead off for you, Dave.
Yeah, absolutely. So the interesting thing is that you're not making or selling the hammer. A patent protects your right to make, manufacture, sell, market the hammer, and so. The patent protects the hammer. If the hammer is protected under patent, it's not preventing you from making something with the product that you bought from them. That's not their sandbox. Their sandbox is the hammer. So unless you were making a hammer that infringed on that hammer, assuming that it's protected under patents, because quite frankly, like there are some cool hammers out there that have some new features and whatnot. There's actually a company that I bought one of the hammers because I was like, this is really cool. I bet they have a patent on this. I really like this product. If anyone really likes hammers, it's Hart, H-A-R-T. But there's so much out there that has been patented. I'm sure a claw hammer had a patent once upon a time. In fact, I know it has, but it's expired. Patents expire. So you have.
We should talk about that. We need to talk about that.
Yeah, I forgot to mention that. That's a very important point, and I'm sorry I didn't bring it up earlier. So
I didn't cover it for trademarks. So yeah, we'll both cover it.
They expire 20 years after the initial filing date, and design patents are, I believe, 14 years now from the date of grant. So after that is done, let's say I patented my newfangled hammer and had all these gadgets and gizmos on it, and I sold them like hotcakes. After 20 years, any one of us could make and sell those hammers and not have an issue. There are ways that when you're a company that keeps iterating and you keep developing your product along that product line and you add improvements. Milwaukee, by the way, is a great example of this. Milwaukee Tools, stay on the tool path. Their old products may not be patentable, but they have new products that have new features. And a lot of time when these features come out, it's not just marketing. I mean, it's based on marketing, but it's because that they can protect it with a patent. They find that it's a valuable add-on. It adds value to the product and the user's experience, and it adds value to their intellectual property portfolio because now they've established a new sandbox, even though that sandbox fell apart after 20 years.
So I'll speak to the trademark. The duration of trademark is interesting because trademark actually can continue in perpetuity. As long as I said at the beginning, trademark rights are based on use. So once you get a trademark registration, as long as you continue to use that trademark, you can keep renewing it and keep renewing it. The trademark office will charge you a fee. You get to file after 5 years, and then it's every 10. But you can, and this is why, no one's the trademark on Coca-Cola is never going to run out, right? It is going. As long as they keep using that trademark, no one else will be able to use something similar. So I think the only other thing, now that someone brought up copyright, the copyright related to the artwork, I also want to make sure just to very briefly mention trade secret, because it is relevant here a little bit. Trade secret is another type of intellectual property. It is what it sounds like. It is something that is confidential, that is not shared with the public, and is important to your business. It could be a client list or a contact list. It could be a process or a recipe. The example we always use is the recipe for Coca-Cola, is the most famous trade secret out there. But to the extent you are creating something that isn't easily discernible in your invention, it's something behind the scenes that cannot be reverse engineered, so to speak, that may be susceptible for trade secret protection. There's no registration process for trade secrets because they're secret. So you don't want to register it and put it in the public, because certainly everything that you register with the trademark office, with the copyright office, that's all public record. And trade secret, you wouldn't want to register. You wouldn't want to put it out there. So,
and Dave, did you want to speak to trade dress? Because I think that's a perfect tie-in between you and Schuyler. Do you get involved with trade dress at all?
Sure. Yeah. I mean, trade dress is about look and feel. Right. So trade. So, and trade. It's interesting because Schuyler can talk about it on the product side. The funny thing is that the famous trade dress case that made it to the Supreme Court was Taco Cabana. So there was a Mexican restaurant in Texas, I believe, that had a very kind of pastels and 50s type look and feel. And another Mexican restaurant opened up, had that very similar look and feel with the same color palette design. And it was found that the trade dress, the look and feel of the restaurant was protectable. So you translate that to products here, certainly, absolutely look and feel is protectable. Trade dress is protectable. And yeah, Schuyler, you had mentioned it earlier.
Yeah, absolutely. And I mean, it definitely translates because a lot of this, I mean, you'll see it with a lot of big brands that maybe don't have a physical product and they already have all their branding. They have a really strong trademark. I mean, Uber is an example where, they don't have any physical products, but then you think about their lights that go on the dash, and then their scooters and things like that. And that all had to be translated over and have the same look and feel as that brand. It's very important. And that's why, I mean, a lot of the times that won't necessarily be established until, from the product design standpoint, we've established colors and we've established whether it's aggressive or it's approachable or it's, kind of stealth looking or something like that for that industry. And that will become part of that trade dress and really represent the brand. And then other products, should in their offering should kind of continue that, if not advance that. And that becomes a really big part of, that product line. And so, yeah, it's definitely important to incorporate and then incorporate from our side, because if we design something that, doesn't fit into that category, then it is, it might potentially even be harder to protect if it's kind of all over the place.
I'm laughing a little because it's for that exact reason that I don't believe that the Tesla Cybertruck is going to look like it currently does.
Yeah, I hear you. I totally hear you on that. Absolutely.
It's not in the same vein of everything else that they've done, and they've created this brand and this look and feel, and like they've protected with design applications, and now they're going with something that doesn't look like it at all. I don't know.
Yeah.
Yeah. But it is interesting, but talking about a line of products, right? Talking about the entire look and feel of a brand overall. I mean, we definitely work on really visioning that ahead of time and trying to make that plan far in advance, because once you start with one, you're going to want others to be in the same vein. So thinking a few steps ahead, and again, and from the trademark perspective, you can do these intent to use applications, but or doing the searches or whatever it is in your step of the process. But thinking ahead is a big part of really getting a successful line out there.
Absolutely.
Yeah, and as designers, we always like to hypothetically, and you'll do it in school. If you go through the industrial design path, you'll say, what if Nike designed computers? What if Apple designed, shoes or cars? What would that look like? And so we're trying to apply, and maybe even it's a complete, it's an app. What if Instagram started designing, a Polaroid camera or something like that? What would that look like? And so that's totally applying those things across those boundaries and saying, all right, how do we take that kind of intangible thing and make it tangible, or vice versa? So It's kind of interesting.
Really cool. We've got one last question in the Q&A. I'll field that real quickly, and then I think we'll each sort of have our little closing and our sort of parting words of wisdom, and we'll let you guys go about your way. So can you leverage a PCT like a provisional as patent pending? Any application that's currently in the system and not granted, abandoned, or expired is pending. So a filed provisional for 12 months is pending. A filed non-provisional that's being reviewed by the USPTO is pending. A PCT application is pending. So a lot of people like the benefit of patent pending just as much as they like the issued patents. You'll see that a lot in the software world because it sort of says, hey, be buyer, sort of competition beware. I'm in this space, but you don't know what my application necessarily says for 18 months. So it's a nice tool to have. So with that said, it doesn't look like we have any other questions here. So I think we'll just go to our sort of closing remarks. And Schuyler, if you want to go first.
Yeah, sure. Yeah, I mean, I'll put my contact info in the chat here. We really appreciate all the questions, and hopefully we were able to answer some of the questions you guys had coming into this. I'll put my, as I said, I'll put my info in there. If you guys, have more questions about product development or anything along that line, definitely feel free to reach out, and I'll do my best to help out. But I hope you guys enjoyed it.
Yeah, I mean, I think same thing. I think that one of the interesting things here is that because I get a lot of these similar questions about cost is a big one, and we all get that, right? We all bootstrap this, and I mean, I bootstrap my company too, and I understand those barriers, and it is just about making those decisions. Certainly, I don't think any of us, charge to have a conversation, just say, hey, should I hire you? Right. So that's always, don't ever hesitate to reach out. I can speak for myself. Don't ever hesitate to reach out just to have that first conversation. And also, if you're looking to hire anyone in any of our fields, interview people, right? You've got a right to choose who you want to work with. Yeah. But, it is something we all are experienced with. That's why we're talking about this today. I think it's great that we get to kind of close out the Maker Track here with some really brass tacks stuff, just to really, hey, this is where the rubber meets the road. But it is really, I imagine we all would say this, and I'll say it for myself, that I do what I do because I love it, because I love being able to work with everybody in our world that has all these great ideas and is really passionate about what they do. And that's what's really fun about Startup Week and about what we do, is just being able to work with creative people doing fun and cool stuff. So it really is a pleasure. Thanks to everyone who's joined us here. I'll put my info in the chat here and see who we hear from next.
Yeah, and Schuyler, if you already I'm not seeing your information up. Go ahead and throw that up there.
I'll drop it in.
And like Dave and Schuyler said, I I love helping people. I love seeing something come in, and I really enjoy helping people get the patent. I've had people come to me and they're talking about, they sort of get nitty picky and they think I'm just out to get them. Quite frankly, I don't want to take your money. I want to get you a patent. There's always a risk with any of what we do, that investment doesn't result in what you wanted. A developed product, as well as it's developed, the market may not necessarily sort of pick up on it like an iPhone. You may be able to go after a trademark and not necessarily get it through. You can certainly go after a patent and not get it through. But what we enjoy doing is trying to give you the best chance to do so. And I love being able to sort of send people to folks like Dave and folks like Schuyler that I know that you're going to get taken care of in that realm just as well as I want to take care of my clients. So with that, I would say just, I love that everyone's on here and thank you for sticking with us. And I think you being here and learning is really the first step. So you know sort of a little bit more about the process and where there can be some pitfalls. I'm gonna put my name up here before I completely close out the meeting. So if you wanna contact me like Dave or Schuyler, you'll have my info.
Well, it's also in the, it's on Denver Startup Week website has our names and our firms. And so we're very Googleable generally, for better or worse.
just get my last name right, that's all.
Everyone loves pronouncing your last name.
All right, guys. Well, thanks everyone for joining. Once again, if you have any more questions, feel free to contact any one of us. We're happy to field your questions. And happy Startup Week. I'm glad we were able to make this happen, and it's kind of cool to close out the Maker Track.
Thanks a lot.
Thanks, guys.
Bye.